record.
Yes, ma'am. Percy Marquis Stewart.
Thank you. Would those who intend to testify please raise your right hands? Do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Yes, yes, ma'am.
Thank you. You may lower your hands. All right. We are here today on final trial for a divorce without children. And the only issue, only two issues that are before the court is the division of personal property. There is no real property. And then the request for attorney's fees, right?
Yes, Your Honor.
All right. Okay. And prior to going on the record, there was a stipulation of some exhibits and they will be admitted at this time. So petitioners exhibits 1 through 5 are admitted and the respondent does not have any exhibits to tender to the court. You all are set at 15 minutes aside. That will include any opening and closing statements should you all choose to make one. You're absolutely free to waive those. Mr. Ford, you're representing yourself. So
Yes, ma'am.
so you're subject to the same rules of evidence just as an attorney is. If you hear an objection made while you're speaking, just stop speaking, allow the objection to be made for me to make a ruling on it. And if you hear me say overruled, that means you may continue to speak. If you
Oh,
hear me
yes.
say sustained, that means you have to stop speaking. You have to move on to whatever question that you're asking. If you're asking Ms. Flanagan a question or if you're testifying for yourself, okay?
Yes, ma'am.
All right. Attorney Evans, would you like to make an opening statement at this time?
Yes, briefly, Your Honor.
Go ahead.
As the court has noted, there is minimal issues of concern today. My client has a couple separate property items that she is asking the court to confirm. With regard to community property, we are fine with each party or asking the court that a just and right division be that each party keep what's in his or her own name. The majority of the beneficial assets are in the name of Mr. Ford, but my client is in agreement to waive any interest to them. And lastly, Your Honor, because the issues are so limited, we are asking for attorney's fees, just because we believe that we didn't have to, go through all this to be here today for the court to decide these things.
Okay. Thank you. Mr. Ford, would you like to make an opening statement?
Yes, ma'am. I don't want anything. I'm not asking anything. I have really no assets of nothing. I just want to walk away what I had the same way on the first petition that she said in the beginning. She want to walk away what she has. The only thing that I ask is I don't want to pay for attorney fees because I couldn't afford my own attorney, and I didn't ask for the divorce. I didn't want the divorce. I still want to work on my marriage. But I can't stop somebody do what they want to do, and I have to respect it. So yes, ma'am. So also with the 6600, also that is a civil case matter, and so that's not doing with the marriage. That was before the marriage. So yes, ma'am. That's all I have to say.
Thank you. All right. Attorney Evans, you may call your first witness.
I call Hersey Ford, Your Honor.
Okay.
Mr. Ford, from that opening statement, just to clarify, since we have such limited time today, so you understand that my client is asking for confirmation for her separate property items, being the house she inherited, her business, and her vehicle?
Yes, ma'am.
Okay, and you're not contesting any of that?
Yes, ma'am. I don't want nothing.
And then with regard to the community property, you also stated that you're fine with each of you keeping the assets as well as the liabilities that are in each of your own name?
Yes, ma'am. When she came in and stuff, like she go away, and what I have, I just go my way. Yes, ma'am.
Well, actually, too, though, what was accumulated or accrued during the marriage, you're also still in agreement that what's in her name will be assigned to her or awarded to her, and what's in your name will be assigned or awarded to you?
Well, what you mean by that?
Anything that was accrued or purchased during the marriage, which I don't think is much. I think you have some retirement that accrued during the marriage. And so I'm just confirming for the court that you're fine with that remaining in your name, and then anything that Tatiana may have had or acquired remaining in her name.
Only thing I'm saying, ma'am, is whatever she has, she can have, and whatever I had came in, I'm just going. Yes, ma'am. So if hers is hers. I didn't marry her to take. I didn't do that. So she can have what she had.
Okay. And then with regard to the $5,600, that was, so I mean, just to clarify for the court, you borrowed $6,000 from Tatiana's grandmother for, I think, wedding costs.
Yes, that was before the marriage. She had gave it to us. Yes, ma'am. That is a civil case matter. That has nothing to do with the marriage. That was
Well,
before.
I understand your position on that, but just to clarify the facts, so Tatiana's grandma gave you guys $6,000 for wedding expenses, correct?
Alright, guys, this courtroom instantly takes a serious turn because what starts as a simple divorce case suddenly becomes much darker. The wife explains that she didn't just hire an attorney over paperwork, she claims she genuinely feared interacting with her husband. According to her, he repeatedly pressured her to meet him in person, forcing her to block over 30 different numbers just to create distance. You can already feel the tension building because this is no longer about property or money. It's becoming a story about fear, control, and emotional pressure behind the scenes.
Yes, something I did not want at the time. And I previously said I didn't want it.
Okay, Mr. Ford, I'm gonna ask you to just kind of respond to the questions that I'm asking because time is limited. You'll have your opportunity. Um,
Yes, ma'am.
okay. And then since that time, you were supposed to make payments to her grandmother, Miss Ora Flanagan. Is that correct?
No, it was no time limit. So no, ma'am. There was no time limit.
I didn't say anything about a time limit, but you were supposed to be making continuous payments to Miss
It
Ora.
was a gift. It was a gift. So it was a gift to me and Tatiana.
So your position is that she didn't loan you the money the way you just testified.
Only thing I'm saying is, ma'am, when she said whenever you have time, help back. And then the situation when we got married, when we got the house, Miss Flanagan did say, don't worry about taking care of the mortgage. And then when me and my wife decided to split up, that's what she wanted, and I didn't want my divorce. That's when Miss Flanagan came to me and said she wanted the money back after she told me I could put it towards the mortgage for the house. And I said, yes, ma'am.
Okay. I've asked the witness, Your Honor.
All right. Mr. Ford, so at this time, because like I said, you are representing yourself, you can either testify of what you want me to know right now, or you can wait until it's your what's called case in chief, and that's when you will present your case and then speak and tell me what it is that you would like.
Yes, ma'am. Either or. I'm just here. Yes, ma'am.
Okay. So she can go ahead and finish her case, and then once she finishes her case in chief, then you can tell me what you want me to know, okay?
Yes, ma'am.
Okay. Attorney Evans, you may call your next witness.
I call Miss Tatiana Flanagan.
Okay.
Tatiana, and you were married or are married to Mr. Hersey Ford.
Yes, ma'am.
When did you guys get married?
We got married May 15th, 2024. No,
Okay.
March. I'm sorry. March 15th, 2024.
And you guys, have you resided in Dallas County for the past 3 months before filing for the divorce?
Yes, ma'am.
And did you reside in the state of Texas for 6 months before filing the divorce?
Yes, ma'am.
Is that also true for Mr. Ford?
Yes, ma'am.
And the marriage has become insupportable beyond reconciliation?
Yes, ma'am.
And with regard to the separate property that's been remedied, the community property, it is your wish that each of you keep what's in your own name, correct?
Yes, ma'am.
Now, if you could tell the court a little bit about the $6,000 that was loaned from your grandmother, who's with you today, correct?
Yes, she is. My great grandmother is with me.
Okay.
Okay, so he and I had an agreement that we would pay for our wedding. So I would pay my portion, he would pay his. I paid my portion. He was unable to pay all of his. So he took a loan of $6,000 from my great grandmother. He was supposed to pay it back. He paid $400 via Zelle back to her. She's reached out to him several times, just reminding him to pay it back. And every single time he would say that he's going to pay it back. He's going to keep on paying it back. He did not do that. I think the last time they reached out, it was September of 2025. So on December 25th, 2025, I paid my great grandmother back that money in cash because she needs it. She needs her money. She has her own medical conditions and things of that nature. And I wanted to ensure that she had it back, being that she loaned it to him for our wedding.
Buckle up, guys, because this is where the husband tries to frame himself as the one who never wanted any of this in the first place. Instead of fighting over assets, he tells the court he simply wants to walk away peacefully and claims he still wanted to save the marriage. But while his words sound calm and emotional, there's already a major disconnect forming between his version of events and what the wife's side is preparing to reveal. He also pushes back hard against paying attorney fees, arguing he couldn't even afford his own lawyer. The emotional tone here feels quiet, but the conflict underneath is already boiling.
And you're now asking the court to order Mr. Ford to reimburse you for that amount,
Yes, ma'am.
totaling the $5,600.
Yes.
In addition to that, do you believe that an attorney was necessary for this case?
Yes, ma'am. Absolutely.
What made me necessary or an attorney necessary?
From May of 2020-25 to the present, Mr. Ford would say that he would sign my divorce papers, especially considering I wasn't asking for anything. He said he would sign it, and then he wouldn't. He wanted me to meet him places. He wanted me to go to dinner, do this, do that. And I just did not feel safe. I didn't feel comfortable to do that. He provided an answer to my petition. He didn't contest anything, which he admitted that. I've had to block over 30 different numbers. He's shown up to my home. And furthermore, we have a history of domestic violence. He has literally put his hands around my neck. He's punched holes in my walls, punched holes in my doors, jumped on my car. He's threatened to commit suicide right in front of me just because I wanted to leave.
And it's because of this that
I wasn't doing what he wanted me to do. So I needed an attorney, yes.
And it's because of this that you didn't feel comfortable adhering to his commands to meet in this place or that place, etc.
Correct.
Even after I came on, or actually, I guess throughout the entire divorce proceeding, has Mr. Ford been cooperative, or have you had to incur additional attorney's fees due to his non-cooperation?
We've had to incur additional attorney's fees because he refused to sign.
This is with the second trial setting in this case?
Yes.
And we've also been set for mediation, or attempted to set for mediation, a couple times without his cooperation, correct?
That's correct.
When we did ultimately go to mediation, was it clear then that that was also a step that wasn't really necessary? His desire was just to drag this out.
That is also correct.
I pass the witness, Your Honor.
All right. You may call your next witness.
I call Aura Flanagan.
Okay.
Miss Flanagan, there was some contradictory statements made by Mr. Ford. Can you clarify whether your intent was to be paid back the $6,000 or whether it was a gift?
Yes, no, it wasn't a gift. Hershey called me, explained his situation, and asked me if I could loan him $6,000. I said yes, I was willing to do that. The agreement was between he and I that he would pay $100 monthly if he could. I did tell him whenever he could, as long as he paid it. He did agree to do this. The last hour. I'm sorry, you have a question?
No, yeah, I was just going to clarify. So throughout that, over a year period, he had only paid $400.
Yes, I have it. He Zelled that to me. So I do have documentation of that, which I had told him that also that I was keeping records of it.
And did he at some point become non-responsive to your inquiries for the money to be paid back?
Well, the last, I texted him while we were sitting in church. I have it on my phone. I believe that was, I have it on my phone. We were in church and I sent it to him, a text to him. And
you don't need the message, your testimony.
Okay. He agreed, and he didn't answer while we were in church, but once we got on the parking lot, he approached me And we embraced and what have you. And he told me, I said, "Did you get my message?" He said, "Yes." He said, "Grandmama, I would take care of that."
Okay.
And that was the last we heard.
Ultimately, he did not take care of that balance, correct?
No, he hasn't.
And in December of last year, Tatiana went ahead and paid you so that you could be made whole from that.
Yes, and she gave it to me for Christmas as a Christmas present, I guess. Yes.
Okay, and that was for the 5,600, the remaining balance,
She
correct?
gave me $5,400. It was
5,000.
5,500. I still have it. No.
Okay, it should be
Yeah.
5,600. Is that accurate?
Yes.
Okay, I passed the witness, Your Honor.
All right, you may call your next witness.
All right, this is where the courtroom starts zeroing in on the controversial $6,000 wedding money dispute, and the pressure immediately exposes contradictions. The attorney carefully questions him about payments made to the wife's grandmother, but instead of agreeing it was a loan, he suddenly shifts the narrative and repeatedly insists the money was actually a gift. What makes this moment powerful is how uncomfortable and defensive the conversation becomes once details start piling up. The court is trying to establish responsibility, while he keeps redirecting the story toward marriage problems and personal struggles instead of directly answering the questions.
Nothing further from this side, Judge.
Okay. So you are raised, and Mr. Ford,
I'm
Go
sorry, Judge. I do need to testify as to attorney's fees, which you have the document in front of you.
Okay.
I am a family law attorney in Dallas, Texas. I have practiced for over 5 years now. I charge a billable rate of $350 per hour. I do believe this rate to be comparable, fair, and reasonable. In this case, the total, well, we capped it at 5,000. It did go a little bit over, but we did a professional courtesy not to charge the client for it. We do believe that these fees were unnecessary in this case. As you can see, not only are there limited assets, but within those limited assets, both parties are in full agreement to keep what's in his or her own name. And so my client is asking that Mr. Ford be responsible for my attorney's fees.
Thank you. Mr. Ford, this is now your opportunity to tell me whatever it is you want me to know based on the questions that you were asked, your side of it,
Yes,
whatever.
ma'am. Yes, ma'am. Yes, Your Honor. I'm gonna make it fair because I'm at 10% on my phone.
Hold on one
So-
second. You're kind of muffled.
Oh, yes, ma'am. I'm at 10%, so I'm gonna go ahead and talk to my phone before it's trying to cut off. The situation.
Hold on one second. Is there some way you can, because the phone is very muffled.
Can you hear me now?
I mean, I can hear you, but it's very faint. And my court reporter has to hear you so she can write everything down.
Okay, yes, ma'am. Let's see. Give me one.
Did he stay closer to the mic?
Can you hear me?
You have an earpiece?
Take it off.
Yes. Yes, ma'am.
Yeah. Let's see if that helps.
Give me 1 second.
Oh, that's better. Much better.
We need to tell them when they have these. Way better.
Hello?
Thank you, Mr.
Yes,
Ford.
that sounds
Hello?
much better. Yes, go ahead.
Can you hear me?
Yes.
Hello?
Yes, we can hear
Can you
you.
hear me?
Yes.
I can't hear you.
You might have to transfer the audio to your. Oh, you can't hear me. Unmute. Let me see.
Hello? Hello?
Can you transfer
Hello?
the audio from your earpiece to your
Judge?
phone? Can you hear me?
Hello? I can hear you now. Can you hear me?
No, you're back on that earpiece.
Yes, ma'am. Let me try to take it out
Is
again. I'm so
it
sorry.
possible to turn it off from the earpiece to the phone?
Hello?
Yes.
I can't hear you, but you can hear me.
Okay.
I can't. Can you hear me?
Yes. Log off and log back on. Can you read my lips?
Judge,
Yes.
I can't hear you though, but you can hear me.
Uh,
Oh wow, and my phone about to die. Hold on. Hello? Okay, I can hear you now. Can you hear me now? I'm sorry.
yes.
Yes, ma'am. I'm so sorry. Okay, I'm at 9% now.
Okay.
Yes, ma'am.
Do
Yes.
can you charge the phone because we have to
Uh,
finish the trial?
I try. I'm out and about at work, and my station is about 30 minutes on the other side of town, and I had to get off the train for the Zoom meeting. And,
Okay.
Buckle up, because this may be the most explosive testimony in the entire hearing. The wife completely changes the atmosphere of the courtroom when she begins describing the alleged behavior that made her feel unsafe throughout the marriage and divorce process. She claims he showed up at her home, pressured her constantly, threatened suicide, damaged property, and even put his hands around her neck. Suddenly, this no longer feels like a disagreement over paperwork. It sounds like a deeply toxic relationship unraveling in public. The attorney uses every statement to justify why legal intervention became absolutely necessary.
I just trying to ask somebody for an iPhone charge. I don't know.
Well,
I'm
just
so
start talking. Just start talking.
okay. Yes, ma'am. The situation with Miss Flanagan when she said that I had called her, that was false. We was at the wedding place that day when we all got in a circle, and I remember informing her that I do not want to take it because I just got out of the hospital. My health is not 100%. They had cut hours from work, and I'm not going to be able to get that to you. She told me that Tatiana deserved the best of everything. I also told her we can get married at the church for free. She gave it to us as a gift. There's no writing statement saying that I must pay back. It's no receipt. And also, I would like to have a receipt showing that Tatiana paid her grandma back the amount that she says. I would like to also see that, or you can see that, Judge. Also with the situation of the fees of her lawyer fees, I could not afford a lawyer. I do not have the money to get a lawyer. I'm in a, so I feel like to each his own should take care of their own lawyer fees because I did not want the divorce. I did not ask for the divorce. And then we had the time to meet up one day for me to sign the papers. And I said, hey, you can meet me at this time frame. And I was signing, we can go our ways. She told me, no, baby, that's not how it's done. We don't do stuff in your timing. That's not how it's going to work. You have a great day. Goodbye, sweetheart, and hung up in my face. So that's what happened. And then when I came to church, I was trying to ask her again because I used to open her car doors and close it for her. We could have did it then. She didn't want to do none of that. So I mean, we didn't need no lawyers. We didn't need anything. She wants stuff done on her time, and that's what that she wanted. So I wanted to sign the papers that day. I didn't have no ill will, no issues, and I still have nothing against her and her family. I wish them all the best. So that right there, man, was false. So, like I say, the 5600 that was something that was given. That's also like a civil case in a matter, and the lawyer fees. That's it, ma'am. That's all. Like I said, I couldn't afford my own lawyer, and we didn't need no lawyers.
Okay. Is that all you
And I
want?
don't want nothing.
Okay. Is that all you want me to know?
Can you hear me?
Yes.
Yes, ma'am. I'm putting the phone to my ear. I'm sorry.
Is that all that you wanted me to know?
Uh, yes, ma'am.
Okay.
I
Attorney,
just like I said, I just want my peace. My soul desires my peace. I wish nothing bad to nobody. I wish everybody well. That's all I'm saying.
okay.
No hard feelings. Yes, ma'am.
Thank you, Mr. Ford. Attorney Evans,
Yes, Your Honor.
go ahead.
I mean, I honestly have nothing further from the court, Your Honor. I rest and close.
Okay. All right. I see it says Flanagan on the screen. Did you ever change your name to Ford?
No, ma'am.
Okay. All right. So I will take this under advisement and I will get you all a ruling emailed out. Okay.
Thank you, Your Honor.
Thank you all.
Well,
Thank you.
You're welcome. You all have
Alright, guys, this final section feels like the courtroom's ultimate credibility battle because both sides are now directly contradicting each other in front of the judge. The grandmother firmly states the $6,000 was never a gift and explains there was always an agreement for repayment, even if it was gradual. Then everything becomes chaotic once the husband begins his response with technical issues, a dying phone battery, and constant interruptions during the Zoom hearing. But despite the confusion, he still pushes back hard, denying key accusations and questioning whether proof even exists that the grandmother was repaid. The tension here comes from watching the judge sort through two completely different stories while the hearing slowly spirals into disorder.